Good morning and welcome to Open Conversation on Atlantic Television Network. Open Conversation is a network's flagship political platform through which trending political news, events, and stories are discussed with stakeholders. Through these conversations, ATN uses political talks about specific issues, party system, and actor to explore hope and engender positive impact to the society. Today on Open Conversation, we'll look at the stories. Rivers crisis. Drop impeachment or face lawsuit. Lawyers warn CJ. And still on Rivers crisis, APC warns against Fubara impeachment. Legislative coup. And Wike's aides mocks Fubara, calls him politically weak. And then on to Abia State. Oti dismisses ex-governor's opposition, calls it political noise. And on Kano State, betrayed Kwakwanso suffer political downfall. Kwakwansia chieftain says. And on Zamfara State, APC denies Lawa's defection rumors. We are open for sponsorship of the program, advert placements, news, events, coverage, and commercials. Watch us live on our website, www.atlanticnetwork.tv, on Facebook and YouTube, Atlantic Television Network. You can also watch us on Avo TV, Niger TV, and Ifastech TV platform. You can connect with us on our ATN socials by subscribing, like, and share. Facebook and YouTube, Atlantic Television Network. Instagram and TikTok, Atlantic TV Network 1, and on X, Atlantic TV Net. We'll go on a short break, and when we come back, we'll delve right into the show. Do not go away. Welcome back and thank you for staying with us. Joining me on Open Conversation this morning is Asim Adams, Esquire. Asim Adams is a regular on Open Conversation. He's a legal practitioner. He's also a human rights advocate, and he is the convener, Lawyers Without Borders. Good morning, Asim, and welcome.
Yeah, good morning, Dorisha. Good morning, Nigerians.
And then on to the story. Association of Legislative Drafting and Advocacy Practitioners has warned the Chief Judge of Rivers State, Justice Simeon Chibuzo Amadi, to withdraw from any impeachment process involving Governor Similaye Fubara or face legal action and a petition to the National Judicial Council. In an open letter dated January 18, 2026, ALDRAP said it will institute a lawsuit and formally reports the Chief Justice to NJC if he considers any impeachment notice from the Rivers State House of Assembly, insisting that his involvement will undermine judicial neutrality. The Abuja-based legal body cited a March 2025 petition allegedly authored by the Rivers State Assembly and submitted to the Department of State Services, accusing the Chief Judge of age falsification as grounds for a clear conflict of interest and likelihood of bias. Signed by Dr. Tonye Clinton Jaja, ALDRAP demanded that Justice Amadi recuse himself and instead writes to the Chief Justice of Nigeria to appoint an independent Chief Judge from another state to oversee any impeachment panel, describing this step as the most honorable and lawful option. Let me start with you, Asim. What do you make of this development?
Well, the development for me is a distraction. They want to use this to distract, what exactly is going on. Now, it's a group, it's an association. So I give it to them that they have the right to their opinion. But whether their opinion is proper at this point in time, that I disagree with them.
Okay.
That they're just looking for, publicity. Because a number of people never knew that particular association. It dropped over whatever the case may be. Only lawyers do know. The last time I heard of this group was they were trying to attempt to create another forum outside of the senior advocates category of Nigeria category, that they wanted their own, whatever, and if possible, another association of lawyers like the MBATC. That is the last time I heard about these people. Now they are coming here now to say this. For me, my own opinion is pure distraction. No, let us even look at exactly what is recusa. When you say recuse, it's like step aside. Babangida stepped aside when there was tremendous pressure on him for misgovernance and the annulment of the 93 election of Abiola. So he had to step aside. So a recusa in judicial parlance is asking a judge in a matter to step aside, recuse yourself because of bias. The fulcrum on which recusa rests is that of bias. And bias has been described or defined by the judicature in a litany of cases to mean you have financial gains to make from the case. You were handling the matter as a lawyer before you were appointed a judge. And that same matter again, you want to sit on it. The parties in this case are your friends. The other one is some likelihood that maybe they are from the same village with you or from the same town, or you worship with the same church, or you have affinity. So the president or chairman of that association says he knows the CJ personally, but I also know the CJ to an extent by virtue of my practice, and if somebody knows me also very well, as the case may be. The CJ is not like people think he is. He's a very principled man. Even when he was a judge, a high-ranking judge at that time, he was principled and at the same time, a protector of the rule of law. There was a particular matter I did in his court. I remember he was always telling the FCC, we must follow the rule of law. This is how it should be. If you go outside of the rule of law, I will not partake in it. And he went for that to give directions and directives and give zest to that particular matter at the point in time that justice, the edge of justice, is what he's after. And I'm very sure that is the reason why he was made, you know, a CJ. Because he had one, I think he had one or two people above him, but he shunted, you know, by, you know, hierarchy. If he had that, you know, boldness to espouse and expand the law and rule of law. So a man of that character, I don't think he will be swayed. I see the CJ as a man, if you put too much pressure on him, he will just resign and say, I don't want this kind of a thing. That is the kind of a man I've seen of him. So when people begin to say things like this, I know he's going to follow the law, and he knows what the law says. Now, this particular group must be informed. And you people, I'm speaking to the chairman of your group, Adrabo, I call you, if you say you are lawyers, yes, I agree with you, maybe you are lawyers. In the legal profession, the first thing is not to intimidate, it's not to cow, it's not to forum shop, it's to allow the CJ use his discretion and rely on his conscience to do the duties imposed on him by the Constitution. And nobody has the imprimatur right to impose, intimidate over all the CJ to do something that he never wanted to do. Recusal is not automatic. I repeat, it is not automatic. Because you have made that allegation does not mean that it will be forced to step down. There are procedures that must be followed. Are you aware that even if you write the right to the judge or whatever the case may be, he has a right to look at facts before him and say, no, these facts do not constitute bias. These facts are not valid enough. These facts are vacuous and lack support, that I am not going to recuse myself. And I have seen situations where litigants have come in because the litigant cannot force a judge to step down. Likewise, this group cannot force a judge to step down or recuse himself. It is not automatic. Under our law, there is no law in Nigeria that says that once you make an allegation, verbose one, vacuous one, shibboleth, plural allegation tied to a remote string floating on the river Niger, that the man will just recuse himself. You are acting based on bias. You are the people who are biased. You are biased right now because you feel that your bidding may not be done. You don't allow for flexibility. That is why you are even advising and advocating that a CJ from another state be brought in. You see, I really don't know the motive. In fact, I have to profile you now and investigate you socially and find out your motive. If you have been, otherwise we ought to be neutral. You are putting, this, vile, pressure on the CJ to no. There are procedures you must have to follow. And I have stated it what the constituents, the ingredients of bias means. Financial, pecuniary interest, personal interest, friendship, etc. Was handling the matter while he was a lawyer before he was made it. Until and unless allegations are proven beyond reasonable doubt, those allegations remain allegations. The CJ.
If I understand what you have said that the allegations that they have brought forth as a reason for bias does not align with what the law describes as bias in the practice of law.
Absolutely. That is for...
And what they are calling bias does not align.
It does not align.
Now, when
it's short-circuited.
All right. When they say the CJ is going to be biased, or when they're accusing him of bias, it's either bias towards the governor or bias towards the House of Assembly. Now, the question would be, to a large extent, the people pushing for impeachment is the House of Assembly. Now, according to Aldrap, that wrote this petition or this letter to the CJ, accusing him of bias, the Assembly petitioned DSS, accusing the CJ of falsification, if you are to go by the statement of Aldrap. Now, to a large extent, if the CJ is going to be biased now, is he going to be biased in favor of the Assembly that had petitioned him to the DSS before, or is he going to be biased in the favor of the governor? Because that's what I'm trying to understand.
In their own, memo or resolution, they never informed us why they feel that the matter before the DSS, that the CJ will be biased. They were neither here nor there. You know what we call chikwata. It was neither here nor there. You understand? They only made an allegation that is open-ended. So it's now left to conjectural, analysis based on what they said. If they had said that having a matter with DSS will now to the fact that many people have said the CJ should not even attempt, looking up, setting up that panel because of that Oyigbo court, injunction,
yes,
interim injunction that was gotten. So the CJ should not even touch it. Now, they have gone beyond CJ not touching, asking the CJ to recuse himself so that an independent CJ, in their own opinion, will come in that will follow court, the court injunction that was given. So, but me, I'm saying that their own take is neither here nor there. I just hazard a guess.
Right.
On what I feel made them do this. But I've said, holistically, shambolic.
Okay.
Yeah, the petition is shambolic. I wouldn't say he does not make sense. Let me not insult their sensibilities. I would just say that petition is frivolous.
Right.
Yes, that is frivolous, allegation. That is frivolous plank on which they are trying to hinge, whatever they want. But indirectly, my opinion is that they are asking the CJ to go so that they can bring in their own CJ that will support the position they hold, which is the position in support of the governor.
All right. So now, if I understand this whole scenario, where they now felt the CJ was going to be biased, or what gave rise to the concern of biasness from the side of the CJ, is because the CJ defied the court injunction and accepted that notice of impeachment, correct? And now his accepting that notice of impeachment has been interpreted to the people on the camp of the governor as the CJ is not going to work in their favor. Hence, this concern that has been flagged right now to paint the CJ as biased. One would now say, if that is the case, does the court in the first instance, does the State High Court, you are a lawyer, Barrister Sims, now does the State High Court even have the jurisdiction to entertain that matter, not to mention giving an injunction? And if the state does not, the State High Court does not have the jurisdiction, should the CJ even entertain that which is already ultra-vires?
The point is this, most of this discourse surrounding Section 188 sub 10 that ousted the jurisdiction of courts in this matter. In my own opinion, if I were to be working for the legislature, that interim order by now, I would have been resisting it.
That have been vacated. To
vacate it, that the court lacks the jurisdiction to entertain this based on the ouster clause. On second plank, what I would have, be hinging my argument upon is that the Nakoju case or the other cases where the courts even intervened, at the Ayade Tiwa, the process right from beginning was faulty then on those states. You understand? There was fault, there was the process and procedure was not followed. So there was a lacuna which the governor lashed in on. But in this Rivers, a case, under section 188 sub 1, 2/3 was gotten. It was not forced. In those states, they didn't have it. They say they didn't even have it, but they gave that the notice etc. as the rest the case may be. You could see that within the next 1, 2, 3 days, these people were not going to follow the procedure of law. But in the Amehule case, Amehule has stated, even it said, we are going to follow the due process of law. And they followed the due process of law, got the notice, got tutor to support it, they served the notices. You understand? On the governor. The governor said he didn't receive. But the House of Assembly said they have served him. So these are arguments that would have been in court to vitalize their position.
But the governor has acknowledged receipt of the letter.
Well, I don't.
And he when he was addressing when he was making a public address during the weekend,
yes,
he said that he has received a love letter.
That is all, love letter. He talks and at times put himself in more trouble. You understand the point now. Now the House said they have served him. And after that service, what has happened now is that the nurse said they have even given the TJ notice. You understand of this? And now asking him now to now set up that 7-man panel. So that's where they stopped. So there was no way or any inkling that they were going to deviate from the procedural course. You understand? So why are you intervening? Why is the court intervening? That's the question we're asking. Why is the court intervening? The court, yes, can intervene where the procedure that has begun is going up to, is going outside of it. So I suspect, and I humbly submit that if an attempt is made to vacate that particular order, they will succeed. Because we want to see in the substantive affidavit that was sworn, the area they said the legislature has breached. They have to tell us.
There has to be a prayer of probably a
breach. So they must say, yes. So the substantive suit must be looked at. To look at the paragraphs that said that Mr. Amehule and the other party member or the House of Assembly members breached that warranted this interim injunction. Mind you, interim injunction is just 7 days. The judge even made it so.
It's an ex parte order that was.
It's an interim injunction that is in between.
All right.
Temporary. Temporary. It's called interlocutory. Right. It's temporary. That's an interim. It's not permanent. It's not perpetual. It's interim. So now what happens is that it's for 7 days or so, and the judge made it close and say this order will last and subsist till 26th or whatever of January. Is it not so? So within this, he now said that the substantive motion be served on the parties. That is the House of Assembly. So the lawyers have to look at, the substantive motion and the affidavit attached to know and see where they said paragraph 5 that the House of Assembly did not follow the 7 days notice or whatever as case may be, and 2 that the governor was not served. Now the question we were talking about, service, would have come in there. What is service? Does service mean when we go there and we did not see the governor, or the governor refused to take the letter from us, and we decide to come back here? If it's in the court, you do substantive means of service. You now bring your order of substantive service, even though you didn't see the person you are supposed to serve. Do you understand the point now? So these are facts that will help us. Now the legislature can say, yes, when we got there, this is somebody that signed on behalf of the governor, even though he was not there. Or when the belief or our messenger got there, he could not serve. He was prevented from entering the government house. They were now ordered that this particular letter be sent to him by post, either by DHL. So service would have come in. And if it is by courier, once the courier has left the office and you have the receipt or whatever happens, it's service. Because I do not need to begin to prove that I've done. The House of Assembly also has an option. Many government institutions may have an option. Many government institutions may have obey court orders in Nigeria. They have an order, they have it, they can on their own follow due process and be doing what they're supposed to do about the impeachment. Then later when they impeach, let them go to court and begin to fight that the due process didn't go through. Since they don't want due process in this case, as case may be now. So these are things that do not even favor the governor, as case may be. You see, the point is, if on that return date, which is on the 26th or whatever, that they return to court, and supervening facts that come, substantial, overwhelming, evidences that come to make them vacate that particular order. What happens? The fourth one, if you want to play the Machiavellian system, you can go to the Federal High Court, because I heard that, somebody said it is the Federal High Court that has jurisdiction over matters of this nature. And then you go to the Federal High Court, go and get your own order. Orders have been flying up and down. The order that we say, compare the CJ to go and, you understand, you now have two combating orders to create chaos and confusion in the system. All these are things open to them. You understand the point? And so I feel, and I'm the opinion, that as far as I'm concerned, I still praise, the equanimity of the legislature in the face of these hostilities and garbage, garbage rascality, from a particular institution. Under our laws, separation of powers, can the court extinguish the right of another arm of government from functioning? Our belief from the onset, no. People should be aware also. Why are people giving, a little oxygen to what I'm doing here? Is because what the order said was that they should suspend the proceedings. They should suspend. You understand? Suspension in the sense that, hold on.
Impeachment should stop.
That the proceedings should stop. Hold on. Open and close. You understand? As from, say, impeachment is not possible. So these are questions that we need to analyze for us to get to the fact.
The question now will be, if we are to periscope that court order that says impeachment should stop, and then because that court order barred the assembly from serving the governor and the deputy governor and from serving the chief justice, and also barred the chief justice from receiving impeachment notice from the assembly. Yes. Now, if we are to look at it that way, that is an interruption of due process, which is entrenched in the Constitution, like you have said. Now, I'm trying to understand the role of and in this instance, Barrister Sims, I had asked you earlier question of jurisdiction, because I recall in 2025, during one of the judgments given by Appeal Court, I think with regards to Okojombo matter, Appeal Court said that, struck out that case for lack of jurisdiction. And he said, why the Appeal Court also made other statements with regards to Okojombo not being the legitimate speaker. The Appeal Court said that the Federal High Court has exclusive reserve of matters pertaining to state assemblies.
Vacancies, yes, vacancy. That is what he talks about, that vacancy.
Okay.
But we're talking about impeachment.
Yes. Now, the question now, I'm looking at number one. It is, like you said earlier, it is a state high court, which, according to Appeal Court, cannot even entertain that matter. Then number two, we are looking at a constitutional proceeding. And then a court order is coming to say you cannot Like they are telling the assembly, you cannot fulfill your legislative rights, your legislative function. This is an arm of government stopping another arm of government in protection of another arm of government. How do we balance this moving forward?
That is when we talk about jurisdiction. Jurisdiction right now is what I would want these people to go to this court. Because let me tell you something. Let us face facts. We practice constitutional democracy and rule of law in Nigeria here. And by virtue of Section 287, Sub 1 for Supreme Court, Sub 2 for Appeal Court, Sub 3 for Federal High Court and State High Courts, every order from a court of competent, composition, has currency, and the Constitution says it should be obeyed and executed. Now, me being a lawyer, I wouldn't want to be outside of the rule of law, whatever as case may be. Now, what I'm saying is that you do not vacate court orders by force of arms or on social media. You vacate orders of court through the courts that gave it. That is why you see today the perpetual injunction foisted on this particular state that sitting governors cannot be tried by that or delay, whatever. It has been difficult for EFCC to vacate the order. But you keep talking about it on a daily basis, whereas you ought to have run to court to go and vacate the order. So what I'm advising in this case is this: iron sharpeneth iron. If you are talking about jurisdiction, absolutely correct. Section 188, sub 10, takes away jurisdiction of court in this matter in terms of proceedings. It is clear, very succinctly stated in lucid prose, that this particular, movement, thank God I have my constitution here. I always go around with this just like a Bible to me, like the pastors carry their Bible. So everywhere I go to, I have my constitution. Now let me tell you how it is. This is the amended, 2023. So it's the recent, complete version of, the Constitution. Now let me go there so that because I lecture also, I teach. So let me. So look at it, Section 188, sub 10. No proceedings or determination of the panel or of the House of Assembly or any matter relating to such proceedings or determination shall be entertained or questioned in any court. This is an master clause.
So in the first instance, Obibo High Court has no business
that is
entertaining that matter.
If you want to read this stricto sensu, if you want to follow this, currently speaking, if you want to follow this as it is stated raw, unedited, the court in Obibo lack that jurisdiction, or any court at all, to look into any proceedings, either by the House of Assembly or by the CJ of the state, that once they decide it, that is the end of it. Then you now go to, section, I think 2, 3, just permit me, let me go through it.
Go ahead.
And you will understand. You will now go to section 1, sub 3 of the 1999 Constitution. He said, if any other law is inconsistent with the provision of this court, of this Constitution, this Constitution shall prevail, and that other law shall to the extent of the inconsistency be void. Now, assuming those who are relying on the Ayade Tiwa case, it is not a law in the Constitution. Many of people have said it happened in Ondo State, the court to put out for the matter. You understand? Assuming that is the law of the courts, Constitution is not saying that any other law in my opinion, with even the Supreme Court judgment or whatever the case may be, is it consistent with this section 188 sub 10? So, if the Constitution says this is how it should be done, then the court is now coming to say you can't do it that way. That negates section 188 sub 10. Because section 188 sub 10 is reinforced by section 1 sub 3 that says if any other law, is it the High Court procedure or is it the similar Fubara law of motion? Is it the law that is crafted by supporters of the governor? That all those laws where you craft, that if they are inconsistent with this particular whatever now, it becomes void. So the question I put to the judge and everybody who are listening to me is that if we agree that the judgment or orders of court are laws, and that particular law made by the Bigbo High Court yesterday or 2 days ago is a judicial law or precedent, and it goes in grain to the Constitution, is that law, is that judgment valid or invalid? I don't know if you get me. Is that law or the judgment valid or invalid based on this section 1 sub 3 that we are talking about? So, for me, I have been a scholar and I was looking at it and said, oh my God. The Constitution section 188 sub 10 says no court can entertain, no court. I was even wondering why they have to put this in the Constitution. That he said, see, the Constitution set up the court. This same Constitution is now saying that the courts I set up cannot even entertain
or stop an impeachment.
Or stop this matter that is before us. But the same court created by the Constitution that says that you cannot go outside the Constitution and do whatever you are doing has now said that they suspend section 188 sub 10. So is that not a conflict of law? So these are things I want people to understand. Don't just talk. Take his side. I want you to, browbeat about this profile this. After all, a lot of things will happen. In chemistry, alcohol is a solution. Chemistry. Yes. People will tell you that is the reason why they are drinking. Because chemistry, in chemistry, alcohol is a solution. So people see that as whatever the case may be. So I'm just trying to twist this whole thing now. For legal jurisprudence, where lies justice? If section 188 sub 10 has suspended courts from even looking at it, why should courts venture into it? These are the arguments for scholars. This is the question I'm asking. And the same constitution that created the courts and created section 188 sub 10 is now saying that if any law is inconsistent with the provisions of this constitution shall prevail, and that other law shall to the extent of inconsistency be void. Now, if that is the situation, if it is a judicial law that was made by the Supreme Court or the High Court, is that particular law not inconsistent with section 188 sub 10? I think students of jurisprudence who can gather and argue and talk about this. Forget about say Fubara and the legislature, but to move Nigeria and deepen democracy and jurisprudence, I challenge, scholars like me to have a colloquium on this to determine. People will say courts, judgment and rulings are precedents. But what if the precedents or the judgment of court negates the Constitution? Is that judgment valid or invalid? By virtue of section 1 sub 3. These are the critical questions. These are things the scholars should take to that court. And even meet the court. Because I'm not advocating, self-help. Run to that court and raise these brilliant arguments. And take it to the Supreme Court. And that is why we scholars have been telling the docile, manipulated, cantankerous, loquacious, assemblage of merchants to deepen our democracy. Either you remove section 188 sub 10, or you deepen it so that there will be no confusion. Now, the reason the courts gave in the locus classicus in this, in NACOJU, etc., PDP, APC, for students, they can call me, I'll give them the citation. Or when you go to your Google, you search. The reason was this, that by virtue of section 6 or so, the judicature has the power to interpret the law.
Okay.
So they can interpret it
in a way that will suit them.
It suits them. That is why law
that's why they say law is subject to interpretation.
Law is subject to interpretation, not just subject to interpretation, subject to the interpretation of those who are interpreting.
All right.
Now, Lord Denning once said that judges, like in this case, judges can expand the law, they can contract the law. In this particular situation, the Nigerian judicature has expanded the law to include that the moment you sense that they are not doing it properly, you have the right to suspend section 188 sub 10, and the court will now lift the veil to now look at what is underneath it. That is what is happening here now. You understand the point? Only students of jurisprudence will understand. Now, the courts are saying our duty is to interpret the laws made by the legislature, and the Constitution is a law made by the legislature. And for us to interpret, we are interpreting section 188 sub 10 subjectively. But even at that, finally, if you look at the judgments in the cases going around everywhere, they said, the Supreme Court said, if there is found to be breach of fundamental human rights of the governor, that is, if you perceive that the process was not done in accordance with the law, you can set it aside. But they now said that even before setting aside, as the process is ongoing, if you smell anything there, you can also do what they did in Obigbo the other day. But the question is this: where did the Amehule?
What is the locus?
What is the offense, or what is the
breach of due process?
The kernel of the argument that warranted them going to court to say the process is not being followed, when the process, only one step or two steps have been taken, and the two steps have been taken, we saw it to be in order. So where lie the miscarriage of whatever there? These are questions that should bog the minds of the judge. And the House of Assembly should not just allow that to happen. Why should they not allow it to happen is that they have to challenge that particular order. When I say frivolous order, set it aside frivolously. Then you cannot have a legal bent for you to do whatever you want to do. Except we want to treat it extrajudicial, which is a norm in impeachment in Nigeria.
All right.
In all of this, let the governor and his crew not be deceived. The legislature holds the head and tail. They can obey, they can disobey, and decide to go on with their function.
Because they are not bound by
That's right.
order.
They be sanitary order.
All right.
When the order elapses, maybe the order elapses on the 26th, And on the 27th, they impeach him. Because the other does not have the currency up to 27, so they go and renew it. If they go extrajudicial and say, oh, since he's doing this, then let us be politically smart. Before they get another order again, we either impeach or we run to Abuja and get another order from the Federal High Court or any other court at all, as the case may be, that will give us the impetus. It happened in Ibadan. Yes, okay, got an order stopping PDP convention. The judge on the other side gave another order that the convention should go on. So that, you see, in a lawless, situation, it will be foolhardy for it to be lawful. Where fools are discussing, it will be foolhardy for you to be wise. So they know what to do.
All right. Very well. Before we move on to the next story, when you were speaking, it struck me. I find it very interesting that, as in the first instance, when you were x-raying this whole issue, they outdrap the lawyers. Now, they wrote a letter or a petition to the CJ asking him to recuse himself, citing bias. However, for lawyers that claim that they draft things constitutionally, which means I expect that they know the Constitution in and out, somehow, by some strange luck, also had amnesia when it come to section 188, subsection 10. They also forgot to raise a petition, to the NJC, informing the NJC. Let's just say they are after the rule of law and transparency. They are so concerned about democracy in Nigeria. Why didn't they call out or even react to the actions of the Obibo High Court, telling Justice Febarissima, this is extrajudicial, right? This is not in line with the Constitution. Understand? Which now brings me to how River State crisis has decimated groups, associations. Everybody is taking side. Probably for some people they call it Orina crisis. A whole lot of persons have turned into that and all of that. So that's my concern. That's what hits me. Like, if they are so concerned, they should have also raised the petition or reacted to that judgment, seeing that this is not in line with the Constitution that you just read.
You see, when people come out and say politics as it is, you are putting him there, you don't allow him to stay. I don't look at them and say, you people don't have conscience. Even if you have conscience, you have deaded conscience. I remember in 2009 or thereabout, Amechi was took over from what was the name, Peter Odili. On national television, Amechi came and said he has 2 billion naira of the previous people in an account. Just the same thing Sim is doing now. There's people say it is because of the 600 billion that they are fighting him. The same narrative they gave that time, that because a lot of problems are happening in that state then during Amechi first tenure. Amechi that came out and said the reason why they are fighting him, whatever, he got the 2 billion naira he has in his account that he has kept for Rivers people. Why this narrative? The question I asked, that 2 billion naira, how far? Who knew how the 2 billion naira was used? The same way this is 100 billion naira, we may not know in the next 4-5 years to come, as the case may be. But they're using it as a narrative. What am I trying to say? When you have problems like this, if you have issues of this nature, many people lose their sense of consciousness and objectivity. The reason is because, like even Amechi reiterated it, that the reason why you see people, flocking, towards civil is because of the hatred they have for Mr. Yesowike. If you look at everybody on this side now, they've lost traction and trajectory of reasoning. When it comes between, nobody wants to hear the other side of the wiki, whatever as case may be. Nobody wants to ask how this child was brought to life. Nobody wants to know who is the mother that took care of this child for 9 months. The labor, the man or the woman, passed through. Nobody wants to know. The only thing is that they felt, oh, is to take him out. So anybody that can do that job, they are ready to support. So when you have mob support, what I call mobocracy, if you have an attitude of mobocratic, people, they will lose their sense of reasoning for some time. That is why you find out that dictators come in with the wind of the people's support. Once they get that and stabilize, they begin to, bear their fangs. In Uganda today, a certain Yoweri Museveni fought tooth to tooth with Obote meeting, Idi Amin Dada, and one other president that came up. All in the name of he wanted to better the lot of the Ugandan people. The Ugandan people surrounded him under the National Resistance Movement, NRM, which was a nationalistic, movement. They said, take this man out by all means. He now entered into it. Today, since 1986, he has been there. I don't know back then to remove he that wanted to remove somebody. So you see, when people begin to give these kind of things, you find out that these are areas people lashing on. These are opportunities, like I told you. The opinions are not based on objectivity again. These are groups that may benefit one way or another from those who they are supporting. For them to come on national TV, coming out with this kind of very far distant, argument, tells you that there's something there. It's just to act as distraction. That is why nobody even took them. I'm very sure that the siege of Rivers State will never take them seriously. He will tell them, go do your worst. You understand? He will tell them, go and do your worst. I will remain here, and I'll do my job as it is. And we are urging the CJ to discountenance. No, not able discountenance. We're asking the CJ to look properly into this particular issue with an objective mind. We know what an interim order is all about, that it is not cast in stone, as the case may be. I'm asking, and I'm saying that they said that that particular notice has been sent to you, acknowledged. Can the court undo something that has been done? That is another question they need to ask. If the CJ has acknowledged that letter, why asking him to stop acknowledging the letter? So these are grounds that the subject matter you are trying to protect has already been carried out. So why are you now telling the CJ to not to look into it? Whereas you say don't receive, he has received. So maybe he may not act on it, but he has already received. So it means the two planks on which you rest, two are gone. All right? This is a very good case that the legislature will take forward, and I believe they will win. Because they have never infracted the process, in my own or in my own view. I've never seen where they have infracted the process.
All right. All right, thank you so much, Barrister Asim. It's a pleasure having you today. Thank you so very much. And thank you so much, our viewers, for always staying connected to us. And this is where we wrap it up on this episode of Open Conversation. We are open for sponsorship of the program, advert placements, news, events, coverage, and commercials. Watch us live on our website, www.atlanticnetwork.tv, on Facebook and YouTube, Atlantic Television Network. You can also watch us on Avo TV, Niger TV, and Efastech TV platform. You can connect with us on our ATN socials by subscribing, like and share. Facebook and YouTube, Atlantic Television Network. Instagram and TikTok, Atlantic TV Network 1. And on X, Atlantic TV Net. Do not forget, peace and unity are the pathways to progress. Thank you for watching. I am Laurentia Ugu. See you same time tomorrow. Bye for now.